Hi there. Hello, Oshin.
Yeah, Oshin, hi. This is Salman Waris.
Yes. Is it possible for the host to check why my camera is not coming on?
Sorry?
I was asking if it's possible for the host to check why my camera is not coming on. I'm having a bit of problem with my camera. So
Hi,
when I turn
Simon.
on, yes, it's Simon.
Hi, Vishwam this side from WebNI. Is it possible for you to share your screen? Because I think there has been some setting issue
Okay,
with your system.
okay. Do you have access to my screen now?
No, I can't see your screen. Are you able to share your screen, Simon? So you can see on
Um,
the Zoom, there should be a green icon saying share screen.
yes, I clicked there, but then for some reason, uh, sort of gone.
Do you have proper network, Wi-Fi or LAN access?
Yeah, I'm using Wi-Fi.
Maybe just can you log out and then
Log back in.
close your, what browser are you using? Are you using Google Chrome or Safari or what browser?
I'm using Chrome.
Okay, can you log out, close Chrome, then restart Chrome and then join again?
Okay.
Thank you. Hi, Simon. Is it still not better? You're on mute, Simon. Hi, Simon. Can you unmute yourself? Hi, Simon. Can you unmute yourself? Can you hear me, Simon? Hi.
Yes. I can hear you. It's just the video is not
Yeah,
working.
I think there's some network problem, Simon, and there's probably some computer setting which is not allowing you to turn your camera. If you're not able to share your screen, we may not be able to troubleshoot it, I think. Can you try once more to share your screen?
Okay, let me try. Well, what happens is when I try, it just stops working entirely. I'll try again. Yes.
Is it not working?
No, the sharing is not
Yeah.
working.
I think there is some setting on your system. I'm not sure what that would be until I troubleshoot that. It's probably just a Wi-Fi as well. So Salman, I'm afraid we'll have to we won't have the video for Simon then.
So are we canceling this session?
No, we can carry on, but Simon will not be able to turn on the video. I think he can still obviously make submissions orally because we can hear him.
Okay. So how do we proceed from here then?
I think basically over to you, but I think the applicants can start making the submissions.
Okay. Yeah, so I would request the applicants to please start making the submissions.
So before I begin, I would just like to bring a small thing to the notice. The senior appellant for this for our team is actually sick, Fatma Nazneen. So I will be replacing her. I'll be arguing on her behalf, if that's okay.
So are you part of the team or
Yes.
you have just...
Yes, I'm part
Okay.
of the team. I'm actually the
Okay.
senior respondent. However, I'll be doing the senior appellant as well because of the unexpected absence. So will that be fine, sir?
Yeah, that's fine.
Yeah, thanks. May it please the court, Your Lordships, my name is Faiza Farhana, and I appear in this case on behalf of the appellants with my learned junior, Ms. Gausia Banu. Your Lordships, I'll be addressing the first ground of appeal, which is the Court of First Instance erred in concluding that it had jurisdiction under Article 5A1B, and my learned junior will be addressing the second ground, which is the Court of First Instance erred in concluding that for the purpose of satisfying Article 37(1)A of the DIFC contract law, that the respondents show a reasonable trader would have concluded that the disputed trade was a result of an error. Your Lordships, in relation to the allocation of time, I will be taking 18 minutes for my oral submissions, reserving the rest for the rebuttal, and the same division will be given to my learned junior as well. Your Lordships, before I begin with my submissions, would the bench like me to reacquaint with the facts of the case? Your Lordships?
Yeah, yes, please.
Your Lordships, Clarity is a digital trading platform. It enables the traders to trade in cryptocurrency. So it also allows the traders to undertake algorithmic trading. And the way it is operated or hosted is through means of distributed ledger technology. And this is hosted across hundreds of nodes around the globe, Your Lordship. Only one such node is in DIFC. So out of that 100, one node is in DIFC. Moreover, these programs that the users undertake are pre-programmed. So they are deterministic in nature and they can conclude trades without any human intervention. The parties to the contract, in this case, that is Mr. Lee Twain and Ms. Rajrani, are such users on the platform. Mr. Payne contracts through his algorithm by the name of Beta, which is programmed to offer his cryptocurrency at an average price in the market. In absence of other sellers, it will sell the cryptocurrency at a highly inflated price. Your Lordships, it's also of prime importance that he is domiciled in Oman, whereas Ms. Razi is in Dubai offshore and she contracts through her algorithm by the name of Alpha. And it is programmed in such a way that it will buy at the best possible price. Your Lordships, on 10th June 2022, what had happened was there was a glitch on the platform. As a result, only those users who had over 200,000 US dollars could trade. And this was in opposition to the normal circumstances of the platform, which is $50,000. As a result, Mr. Payne's algorithm, that is Beta, offered to sell cryptocurrency to Ms. Razi at a highly inflated price, to which Ms. Razi's program had consented. Your Lordship, all this had happened when both the parties were asleep, and upon realizing that this trade had concluded, Ms. Razi issued proceedings in the Digital Economy Code. The Digital Economy Code had held that it had jurisdiction and that there was a relevant mistake under Article 37(1)(a) of the DIFC contract law, Your Lordship. Your Lordship, that concludes the summary of the facts. In relation to the first round of appeal, Your Lordships, I have two submissions to make. The presence of the node in DIFC doesn't allow for the exclusive jurisdiction under Article 5A(1)(b) of the Judicial Authority Law, Your Lordships. Your Lordship, this is because transactions on a distributed ledger, they do not pertain to a specific node. As the name suggests, these distributed ledgers are decentralized. As a paragraph 1 of the Moot problem clearly states, there is a simultaneous access, validation, and record updating. The peculiar feature of transactions on distributed ledger is that they are not initiated at a specific point. So when a transaction occurs, all the nodes on the network must validate for the transaction to be performed. Therefore, in that aspect, it would be completely arbitrary to rely on the fact that just because a node was present in DIFC, that node had validated this transaction, Your Lordship. The presence of the node in the DIFC could be for several reasons for the platform. It might be for the point of contact for the users to take part in Clarity. Your Lordships, for this, I rely on two authorities. Firstly, the UK's Law Commission, in their advice to the UK Parliament, in the document titled Smart Legal Contracts on November 2021, in page number 193 and 194, clearly states that it would be completely arbitrary to rely on the nodes for determining the jurisdiction. It was stated that basing the place of performance of the transaction, which is the base of Article 5A(1)(b) of the Judicial Authority Law, is arbitrary because the node is an artificial place of performance. The transactions in a distributed ledger, they occur on the virtual medium of the internet, Your Lordships. Moreover, in the views of the same authority, they had stated that the location of the node do not correlate with the place of performance. Therefore, it does not seem appropriate to locate the jurisdiction of the contract on that specific feature. Moreover, the Chancery Bar Association and the Commercial Bar Association's view are also in alignment with the same. They have stated that the correct line of approach in such a matter would be to trace back to the domicile of the party who has initiated the relevant transfer. For example, in this case, as before the transaction had concluded between both the parties, it was Mr. Payne who was in ownership of the cryptocurrency Apple. The jurisdiction would pertain to his domicile, that is Oman, Your Lordship. Your Lordship, in support of this, I have two case laws that I would like to cite. Firstly, in the case of Alibaba Group Holding versus Alibaba Coin 18CV2897, which was held in the Southern District of New York for the Court of Appeal for the 6th Circuit in 2018. The judge had clearly stated that the nodes cannot be determinative of jurisdiction. It is because where the transaction is put on the ledger is not relevant. It would constrain a common knowledge to arrive at a conclusion. Just because the location of a server is in remote places, the place of performance would pertain to that. but rather we must look at the parties where the contract is initiated, where in this case it is clearly at the domicile of Oman, Your Lordship. Apologies, domicile of Mr. Payne, that is Oman. Your Lordships, this view has also been put forth by other law commissions, in specific by the European Commission in their document titled Smart Contract and Digital Single Market Through the Lens of Law and Tech. Furthermore, Your Lordships, in the case of Ion Science Limited versus Persons Unknown, in the commercial courts, it was held that location of the cryptocurrency prior to the transfer would pertain to the jurisdiction, which again is clearly indicator of the fact that it is clearly Oman, Your Lordships. Moreover, there is a lack of a good arguable case. This was laid down in the case of Brownlee versus Four Seasons Holding. It was stated by principle, in order to prove a jurisdictional gateway, there must be an evidential basis, which is apparent from the facts of the case. There is a lacking of an evidential basis. Only the presence of the node is not an evidential basis for the transaction that has been concluded. In that absence, we cannot rely on mere assertions and assumptions, Your Lordship. Furthermore, the facts of the case are completely silent in regards to an opt-in clause. When there is a lack of exclusive jurisdiction, it is upon the parties to opt into the jurisdiction of DIFC. This is mentioned in Article 582 of the Judicial Authority Law number 12 of 2004. And in the case of Lotto versus Lettery, 2021 DIFC Small Causes Tribunal 034, it was stated that since there was a lack of exclusive jurisdiction and lack of an opt-in clause, DIFC had no jurisdiction, Your Lordships. Your Lordships, moving on to my second submission, is the principle of forum non-convenience. Your Lordships, this principle of forum non-convenience was elaborated by the court in the case of Protivity Member Firm Limited versus Al-Mohal 2016 DIFC Court of Appeal 003. Your Lordships, when it is sufficient that there exists another forum that's more appropriate, the matter must be litigated in that specific forum. Though this case might seem to be of a cryptocurrency case, at the core of it, it's a contractual dispute, Your Lordships. Relevant mistake is a contractual matter as opposed to a cryptocurrency matter. There is nothing in the facts of the case apart from the location of the node which would deem it to be of a major cryptocurrency dispute. Relevant mistake happened in both normal contracts in normal circumstances and in digital contracts, Your Lordships. In that aspect, Your Lordship, as I reiterated earlier, Oman would be the appropriate forum to litigate upon the matter, and they have the right legislation in place to govern the matter. For this, I would like to state that there is a specific act in Oman which governs the matter of digital contracts, which is of prime importance in this case, by the name of Electronic Transactions Law 2008. In fact, the Article 13 of this act clearly gives validity to algorithmic trading. Therefore, the presence of the programs in this matter would be efficiently litigated upon by this court, Your Lordship. Furthermore, though the facts of the case are not clear in regards to a governing law, even had the governing law be DIFC, the Omani courts could still execute or implement that governing law. This is clear from the Article 21 of the Civil Transactions Law of the Oman. It can give effect to the applicable law of contract, Your Lordship. Therefore, in the light of this, there seems to be no bar that would prevent Oman from litigating upon the matter because it is just as efficient as the courts in the present. And I stated earlier in my first submission, domicile of the plaintiff in this case, appellant in this case, apologies, Mr. Payne, is of prime importance as reiterated by the UK Law Commission as well as UK Jurisdictional Task Force, Your Lordships. Moreover, the Omani courts do recognize the legal existence of cryptocurrency. There is not a single mention of it being illegal or that trades in cryptocurrency would be invalid. In fact, the Capital Markets Authority have appointed an advisory to regulate upon this matter by the name of Regulatory Framework for Virtual Asset Service Providers, Your Lordships. In that regard, Your Lordships, I humbly submit that the presence of one node in DIFC would not allow for the exclusive jurisdiction of Article 5A1B. The transactions and contracts and the distributed ledger technology do not pertain to a specific node, but upon the consensus of multiple nodes, which is not sure if this node in DIFC is even a part of that consensus mechanism. Therefore, we should not rely on the mere assumptions that are not clothed by facts nor evidence, Your Lordships. That concludes my first round of appeal, Your Lordships. It was a pleasure arguing in this court. If I may be of no further assistance, I will now refer this court to my co-counsel for addressing the second round of appeal. Much obliged, Lordships.
Faiza, I have a question for you. In terms of
Yes, Your
the
Lordship.
jurisdiction, and can you hear me?
Yes, Your Lordship.
So, in terms of the location, you had argued with regard to the fact in terms of your argument relating to the non-jurisdiction of the court. So, is there anything else that would be, in addition to what you have submitted, that would prove beyond reasonable doubt that the person in this case was located in Oman? Because as of now, it's just the fact that they were Omani citizens that you have argued that the jurisdiction would lie in Oman.
Yes, Your Lordship. May I please guide you to the facts of the case, Your Lordship? If you may please allow me a minute, Your Lordship. Your Lordships, on page number 3 of the code bundle, paragraph 3 of the Moot ruling clearly states that Mr. Payne resides in the Sultanate of Oman, Your Lordship.
Yeah, that's right. So they do generally reside, but at the time when the incident happened, was he resident or was he at that point of time in Omani jurisdiction or was he in Dubai or UAE? Is there something else that can substantiate that?
Your Lordship, there's nothing in the facts of the case that suggests that he might have been living anywhere else but Oman.
Okay.
However, we can positively assume that since the facts of the case are pretty evident to the residents of Mr. Payne in Oman, and there is nothing other than that very fact that would negate this factor, Your Lordship, we can conclude that he's domiciled in Oman.
Yeah, thank you. Your co-counsel can present their
Much
arguments.
obliged, Your Lordship.
Good afternoon, Your Lordship. May it please Your Lordship, as already been indicated, my name is Gausia Banu and I appeal on behalf of the appellants in this Court of Appeal in relation to the present ground of appeal. I have two submissions to make. The first submission being, there was an inherent risk involved in algorithmic trading using pre-programmed softwares. It is quite evident that automated technology brings with it certain significant risks, which the users should ideally reasonably assume. Moreover, a report published by the European Commercial Bank in the year 2020 substantiates this point. The report analyzes how trading errors and incidents can be linked to systematic errors and operational failures. This is what has happened in the present case, where an error on the platform Clevity had led to the disputed trade. This trade was performed by the appellants and respondents' respective algorithms, which were programmed specifically by them to carry out the trading. As explicitly mentioned in the Moot problem given, I may refer Your Lordship to page 4 of the bundle to para 6, where it is provided that the appellant was asleep and unaware of the unusual changes in the market conditions on the Clevity platform. Moreover, according to a research paper titled Critical Analysis on Regulating Algorithmic Trading in the New Capital Markets in the EU Regime, published by the University of Oxford in 2020. This research paper explains how algorithmic trading is particularly vulnerable to machine-driven errors and biases, which can travel fast and correlatedly across the markets. There are various inherent risks which are a part and parcel of the very nature of the algorithmic trading. This is because algorithmic trading is automated and disintermediated. Moreover, Your Lordship, both the appellant and respondent voluntarily engaged in algorithmic trading, employing their pre-programmed software. The respondent should have reasonably known the risk associated with the use of deterministic programs for trading. These autonomous programs self-execute the trading agreements based on their programming. While these algorithms are developed by humans, the actual decisions to send orders to buy or sell the cryptocurrencies are made by the algorithms based on their deterministic programming without any human involvement. Moreover, may I refer your lordship to Article 37(1)(a) of the DIFC contract law, which was utilized by the Digital Economy Court to vitiate the disputed trade. The Article 37(1)(a) speaks about relevant mistake and the conditions based on which a party may avoid the contract. Your lordship, the Article 37(1)(a) of the contract speaks about how a reasonable a person in the same situation as the party would not have concluded in at all if the true states of affair had been known. The other party made the same mistake or was also mistaken or caused the mistake or knew or ought to have known about the mistake. However, all these conditions are not satisfied in the present case. Your lordship, may I refer to Article 37(2)(b) of the DIFC contract law, which can be referred to, which states that a party may not avoid a contract if the mistake relates to a matter in regards to which the risk of mistake was assumed or having regards to the circumstances should be borne by the mistaken party. In the present case, as already been established, there was an inherent risk present in the programming. Moreover, when some or all the stages of a contract's life cycle are automated without subsequently allowing for adjustments or any human involvement, the computer code representing the contract needs to be precise and it needs to be fully defined to account for any contingency. Hereafter, in the present case, the appellant's program beta was properly programmed to sell it at the best possible price according to the market conditions on the Clevity platform. Your lordship, as given in para 8 of the facts of the case, given in the moot problem itself at page 5 of the case bundle submitted, the appellant did not make the same mistake while programming beta as the respondent did while programming alpha. And he did not know or could not have known about the respondent mistake and the error which was on the platform Clevity when the disputed trade was conducted. Moreover, your lordship, preset algorithmic programming and modeling seek to abstractly represent the state of the market and a desired trajectory for trading as to how these trades are to be conducted. According to a report published by the Stanford Technology Law Review in the year 2017, states that when algorithms are introduced in institutional decision making, individuals outsource their valuation processes to the algorithm. Moreover, your lordship, according to a report published in Vanderbilt Law Review Journal in the year 2015, it states that algorithms have been shown to be limited in their ability to develop and apply long-run knowledge and strategies in their tradings. That is, these algorithms are incapable of modifying themselves in cases of changes in circumstances. They're deterministic in nature. May it please your lordship, I would humbly like to submit my second ground of submission, which is mistakes in pre-programmed softwares cannot be attributed to the appellant's reasonability and foreseeability. The appellant in the present case had no actual or constructive knowledge about the error on the platform. Moreover, your lordship, it should be noted that the mistake is a cryptocurrency pricing error caused due to the systemic error in the platform Clevity. May I refer your lordship to the case of Smith versus Hughes, 1871, LR 6QB597, and Statoil ASA versus Lewis Dreyfus Energy in the year 2008. Your lordship, in these cases, the court justified its conclusion about how the contracts cannot be avoided based on unilateral mistake by characterizing it as a mistaken assumption about the circumstances under which the contract or would have been concluded. There was no mistake as to the terms. Rather, the mistake was regarding the circumstances. Furthermore, your lordship, may I refer to the case of Coin Private Limited versus B2C2 in the year 2020, held in the Singapore Court of Appeal. The Singapore Court of Appeal held that there was no unilateral mistake, whether at common law or at equity. The Court of Appeal held that the disputed trades and the trading price of the cryptocurrencies were the result of deterministic algorithms deployed by the B2C2. these algorithms had acted exactly as they had been programmed to do so. In fact, the actual mistake here was a mistaken assumption on the part of the counterparties as to how the platform operated. They had assumed that the platform would either always operate as intended, or there would be adequate systems to prevent trading from continuing if there are any discrepancies in the platform. Moreover, the developers of any smart contract must have envisaged the scenarios to act and outline limits and boundaries as to how it should do so. Moreover, I would like to state that the concept of reasonable trader cannot be brought in the present case, since these trades were completely automated. That is, there was no human involvement in these trades. These algorithmic programs are incapable of generating new responses as per the change in circumstances, Your Lordship. Moreover, Your Lordship, in para number 10 of the facts of the case, it is explicitly stated that the DEC code, that is the Digital Economy Code, applied the reasoning of Lord Mans in the case of Coin versus B2C2 in order to come to a conclusion that it was reasonable with the knowledge of the circumstances that the disputed trade was a result of an error. However, Your Lordship, I would humbly like to submit that Lord Mans's opinion was a dissenting opinion. That is, it was a minority opinion. And in the final judgment of the B2C2 case, it was based on the majority opinion, which stated that there was no unilateral or relevant mistake at common law or at equity. Hence, Your Lordship, I would like to state that in order to avoid the disputed trade, it was not sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law. Furthermore, Your Lordship, hence, with that, I would like to conclude my submissions by humbly submitting before this Honorable Court that the Court of First Instance erred in concluding that for the purpose of a claim to avoid the disputed trade, it was sufficient for the purpose of satisfying Article 37(1)(a) of the DIFC contract law. That's it, Your Lordship. May I be of any further assistance to this court? It was an honor arguing in the court.
No, thank you. You mentioned something about a mistaken assumption rather than a mistake in the programming. Can you
Yes, Your Lordship.
further substantiate that with some reasoning?
Yes,
Why
Your Lordship.
you evaluate that? Yeah.
Yes, Your Lordship. So I would like to say that both the appellants and respondents, they consciously entered into algorithmic trading, and these algorithms were pre-programmed. That is, they were deterministic. So they would function according to what they have been programmed as. And about the mistaken assumption, there was what I would like to submit is that there was no mistake on behalf of the appellant while programming. The mistake here, which was referred to in the case, is regarding the circumstances as to the functioning of Clevity, not the programming on the behalf of the appellant, Your Lordship.
Okay, thank you.
Thank you.
May the defendants please present their case. Simon, are you there for defendant?
Yes, my lord. My lord.
Are you going to be arguing first, or it's going to be your co-counsel? Who's going to be
My lord,
taking the...
I'll be the junior counsel and I'll make the substantive submission. But before I do that, my senior counsel will make some sort of introduction, giving some kind of background to our case.
Understood. So who's going?
Hello.
Yeah, Fatima.
Hello.
Okay. Yeah.
Hello, Your Lordships. I'm Fatima Namazi, and I'll be the senior counsel for this case.
Fatima, I cannot see you. Have you switched on your video?
Can you see me now?
Yeah, I can see you now.
Sorry
If
about
it's
that.
for religious reasons that you do not want to display the video, it's fine with us.
No, I'm fine with this.
Yeah.
I'm Fatima Namazi, and I'll be the senior counsel, and I'll introduce the case and give a little bit of background, if that's okay, Your Honor.
Yeah, please go ahead.
Basically, Cleverty is a software program which allows people and clients such as Ms. Rani and Mr. Payne to use the platform to introduce their own platforms and their own business. Overnight, there was a technical glitch in the programming, specifically Cleverty software, because they were doing a routine upgrade, and as a result, there's a lot of the Cleverty users lost a lot of money. Overnight, because of the glitch, and also when the disputed trade was in contact with Cleverty, it provided Ms. Rani to pay 250 US dollars more than Mr. Payne. Well, we believe and we argue that Ms. Rani did not know that was going to happen, and because she was in sort of like a contract with Mr. Payne, she believed that if she knew that there was some kind of upgraded routine and glitch and would have to pay a lot more money, she would not enter the contract and would not be in agreement with Mr. Payne. With the use of Article 37, subsection 1A of the DIFC contract law, that Ms. Razi actually had some kind of reasonable knowledge within her platform, and especially surrounding the transaction. And because of it, she did not know that anything was going to happen. She did not know the glitch was going to happen. Therefore, she would not. She's not. We believe that and argue that she won't be able to pay 250,000 US dollars. We also believe and argue that there was some sort of error within the disputed trade and with Cleverty's arguments. If I now hand over to my colleague, Mr. Simon Ozari, I'm sure he'll be able to take it from there. Thank you, Your Honours.
Thank you, Fatima. Go ahead, Simon.
My Lord, if you permit, you may proceed to make substantive submission on behalf of the respondent who we represent today, myself and my able learned friend.
Yes,
my Lord,
proceed.
Thank you, my Lord. My Lord, the case before the court, the question before the court today lies on two grounds which have been brought forward by the appellant. And I'll take it in turns. My Lord, the first ground is the issue of jurisdictional challenge. My Lord, before I address that issue, I would like to make some preliminary points. The first point is that nowhere had it been demonstrated, based on the facts of this case, that at the point of the first instance hearing at the DEC, at no point did the appellant raise any jurisdictional objection. This jurisdictional challenge that we're dealing with now comes after a full substantial hearing has been undertaken by the DEC and the decision has been given. So this particular ground for appeal, I would argue, is a matter of an afterthought. The other preliminary point I want to mention is that there's no evidence or any suggestion at all that the appellant brought any anti-suit injunction at the DEC to stop the proceedings at the DEC. What the appellant did was to join the proceedings from the beginning to the end. It is strike law in common law, and we've been advised that this court will find common law principles persuasive, that if you join in a proceedings, and even if you didn't agree with these proceedings where you join and you did not make any anti-suit injunction, you essentially have waived your right not to join that proceeding. So those are my preliminary points. I will now progress to deal with the grounds in turn. So ground one, the respondent rejects the appellant's argument or point that the DEC or the DIFC courts had no jurisdiction to determine this case. It is actually the case of the respondent that the DIFC courts had jurisdiction, and their jurisdictional power arises out of Article 5A1B of the Judicial Authority Law, Dubai Law number 12 of 2004. My Lord, I don't know if you look at that particular article, it makes references to dealing with any disputes or civil claims that arise within or in relation to the DIFC jurisdiction. But then it makes one important point. It talks about incidents. In this case, Clarity, which is the platform that was used, operates nodes, and one of those nodes was operated within the DIFC. Before I proceed, I would like to bring the court's attention to the meaning of a node. So a node is a point in a network or diagram at which lines or pathways intersect or branch. That means that is evidential by its very nature, its inherent nature, that the trade that was concluded couldn't have been concluded if the node within the DIFC jurisdiction did not operate. And so from the point where the nodes operated at that crucial point in time, the DIFC will correctly have jurisdiction to determine this case. My Lord, I support that proposition with the case of Al-Khurafi and Bank Saracen, referring to paragraph 60 and 65 of that case. My Lord, I also support this proposition with the recent case going on at the DIFC Court of Appeal, the case of William Allen Jones, Coffee Planet LLC, Coffee Planet Roastery FZE against and Robert Anthony Jones. In this case, it's been reaffirmed that the DIFC courts has broad jurisdictional powers. So Article 5A1B essentially is interpreted broadly rather than narrowly. My Lord, the DEC correctly concluded that it had jurisdiction since Clarity operated through a distributed ledger, and one of those nodes, which, as we've pointed out, was based in the DIFC and operated actively for the trade to have concluded. My Lord, I will now move to the second ground. The second ground of appeal from the appellant is asking the question whether the court was right to not examine the state of mind of the programmers. My Lord, I suppose the answer to that is yes. The DEC court correctly did not need to assess the state of mind of the programmers when they designed the program, because for the purposes of Article 37(1)(a) of the DFC contract law, what was needed was for an objective trader, a reasonable trader, who've had all the information or the background regarding this particular trade, to come to the conclusion that the trade was conducted in error, one, and secondly, that having been conducted in error is made the contract to lose its commercial purpose. My Lord, I know that counsel for the appellant mentioned that the criteria under Article 37(1)(a) of the DFC contract law have not been met. My Lord, I beg to differ. My Lord, I'll take you to that article, and I quote. The article reads, "A party may only avoid a contract for mistake if, when the contract was concluded, the mistake was of such importance that a reasonable person in the same situation as the party would not have concluded it at all if the true state of affairs had been known. And A, the other party made the same mistake, or was also mistaken, or caused the mistake, or knew or ought to have known of the mistake, and it was contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error." My Lord, the point I would like the court to take from this is the area, the part of this article that says, or ought to have known of the mistake. So the parties, as counsel for the appellants have mentioned earlier, we are well aware of the risk of using an automated trading. And so that demonstrates that the appellant ought to know, to have known that if there are risks that could come from technical glitch, then this could lead to mistake in the trade. The second point I want to make is that once that risk has taken place, and the trade has been conducted in error, it becomes contrary to reasonable commercial standards of fair dealing to leave the mistaken party in error. So essentially, Article 37(1)(a) of the DIFC contract law, the criteria was met, and the DEC court was correct in finding that that criteria was met. My Lord, it is common ground that there was an error in the trade, because the parties do accept, both parties do accept, that Clarity, the platform, do not have any liability, even though there was an error. So there was an error. So at that point where it was agreed that there was an error, what it then means in layman's term is that the respondent is not saying, I did not have a contract with the appellant. What the respondent is saying is, I did have a contract to exchange cryptocurrency with the appellant. However, the contract I had is not the same with the supposed or the alleged contract that actually then was conducted. What was conducted happened in error. It happened in error. It is common ground that the cryptocurrency was exchanged at a rate 250 times higher, a whopping rate of 250 times higher than the above market rate. There is no gainsaying the fact that this means that the contract has lost its commercial purpose. And so the court was within its rights to have applied the reasoning of Lord Mons in Quinon PT Limited and BC C2 Limited 2020, even though that Lord Mons was dissenting. But for the specific facts upon which this case rests, the court was well within its right to have found in favor of the respondent. My Lord, I would like to support this proposition with some more case laws. It is the respondent's case, simply put, that a contract may be discharged by frustration. A contract may be frustrated where there exists a change in circumstances after the contract was made, which is not the fault of either of the parties, which renders the contract either impossible to perform or deprives the contract of its commercial purpose. So the key point here is that once the error had taken place, it's common ground that there was an error. It rendered the contract that was ab initio agreed impossible to be rightly performed. Not just did it render it impossible to be correctly performed within the 50,000 USD limit, but it also deprived the contract of its commercial purpose. And so the criteria for a frustrated contract was met on that ground. I will take you to 3 more case laws. So the case of Nicola Knight, Ashton, Elrich, and Kerr. I'll give sort of a brief background about this case. So by contract, the parties agreed that a cargo of cottonseed was to be shipped from Egypt to England. The contract specified the ship, the Orlando, which was to carry the cargo. This ship became damaged and was in for repairs when the contract was due to be performed. My Lord, in this case, the court held that by the parties naming the exact ship which was to carry the cargo, the contract was frustrated as it was impossible for this ship to carry the cargo within the contractually agreed period. So there were ships that could have carried, but the parties have defined, they've stated that they want the Orlando. If you bring that to the present case today, the parties have defined and stated in conjunction with Clevity that the amount of money needed to trade was 50,000 USD and not 200,000 USD or anything more than 50,000. And so where an error has taken place, the contract has been frustrated. There is also the case of Krell and Henry, 1903, at paragraph 40. The court notes that the defendant hired a flat on Pall Mall for sole purpose of viewing King Edward II's coronation procession. The price agreed was £75 for 2 days. The defendant paid £25 deposit. Due to illness of the king, the coronation was cancelled. Consequently, the defendant did not use the flat. The claimant sought to claim the outstanding £50. In this case, the court held that the contract was frustrated as cancellation of the procession deprived it of its commercial purpose. The claimant's action for breach of contract was thus unsuccessful. My Lord, if we take that principle and apply it to today's case, once the platform operated in error and operated and exchanged cryptocurrencies 250 times at a rate 250 times above the fair commercial dealing of the market rate, what it means is that the contract lost its commercial purpose. And so the contract...
Simon, if I may intervene, you need to conclude your arguments quickly. You're running out of time.
Thank you, my Lord. I'll be concluding. My
Yeah,
Lord,
just present your concluding arguments. Yeah.
Just to conclude, the last authority I would like to refer to is the case of Hartog and Collin and Sheds. And I quote, since the plaintiff could not reasonably have supposed that the stated price was correct, he could not accept this offer made by mistake. An offeree cannot snap up, in quotes, an offer which he knows or ought to know was made in error. My Lord, the appellant cannot snap up an offer or snap up a trade that lacks commercial purpose and which was made in error, which he was well aware that automated programming could lead to an error. So essentially, the case of the respondent is a matter of non-factum X, not by the will of the respondent that trade was concluded. And so, my Lord, those are my submissions, and I invite this honorable court to dismiss all grounds of appeal from the appellant. Thank you, my Lord.
Thank you, Simon. Which one, how do we proceed from here? Do I just give them the scores and we conclude this?
So we have rebuttals.
Yes, Salman. So
Yeah.
we have rebuttals.
Okay, sorry, yeah, the rebuttals. Yeah, please.
And the
please go ahead.
scores you can directly send to. We can discuss and send to Delvin then, and then you can
after
give feedback
after the rebuttals.
Yeah, and then you can give feedback in the end before closing the meeting.
Sure.
Thank you.
Yeah, please go ahead, Fatma. Was it Fatma or
Faiza.
Yeah.
Yes.
Go ahead.
Your Lordship, the respondents have made a severe error in regards to the facts of the case in stating that they haven't raised any contention to the jurisdiction, which is wrong. Your Lordship, if you please refer to the code bundle, especially the Moot code problem, specifically paragraph 7 and 11, clearly states that Mr. Payne had contested the jurisdiction. Again, contested, which is why the matter is now in the Court of Appeal, Your Lordships. Secondly, the respondent have also stated that the presence of the node in DIFC gave the jurisdiction. However, the respondents have failed to substantiate or even prove the jurisdictional gateway under Article 5A1B and specific to the matter of incident. Thirdly, Your Lordships, Al-Khurafi case must be distinguished from the present case because in Al-Khurafi case, the matter is in regards to banks, and banks by
Either
nature
just
are
hold
more
on. Either just hold on. El Said, you need to mute your iPad. El Said, you need to mute your iPad. Which one can you do it, please?
Ocean, can you mute outside, please? Ocean.
Yeah.
Thank you.
Sorry, Faizai, please continue.
Yeah. Your Lordships, furthermore, the respondents have relied on the case of Al-Khurafi versus Bank Sirasan. Your Lordships, I would like to distinguish that case from the present case at hand. In that case, the matter was between banks. So banks by nature are more centralized in opposition to the present case. Nodes are decentralized. That is a peculiar aspect of the distributed ledger technology. So one cannot rely on the Khurafi case for proving jurisdictions in regards to this matter. Moreover, the respondents have addressed incident in Article 5A1B, which is flawed. The counsel for the respondents have argued in regards to Delmet mistake, which is a contractual dispute. But incidents are gateways in relation to tort, which is not relevant to this case at all. Your Lordships, that concludes my rebuttals for the first round of appeal. The rebuttals for the second round of appeal will be taken up by my co-counsel.
Good. Yeah. Go ahead, Gausia.
Yes, Your Lordship. Your Lordship, firstly, I would like to point out that my learned opposing counsel has used the concept of frustration. However, I would like to contend that by stating that the doctrine of frustration can be applied only when the contract has not been performed, either wholly or partially, which is not the present case. Your Lordship, however, in the present case, as per the facts of the case given in para 6, specifically page 4 of the case bundle, it is provided that the trade has already been performed and automatically settled on the Clevity's platform. Hence, the performance of the contract has already been done and the doctrine of frustration cannot apply. Moreover, Your Lordship, my opposing counsel he has pointed that there was an error on behalf of the appellants. However, Your Lordship, I may point that the error, the technical glitch, was on behalf of the platform Clevity and not in the deterministic pre-programmed software programmed by the appellant. Moreover, Your Lordship, Lord Mance's opinion, which was referred to by the opposing counsel, was a dissenting opinion. It was a minority opinion. However, the judgment in the court, in the case of B2C2, that is Coin versus B2C2 in the Singapore Court of Appeal, was based on majority opinion, which stated that there was no mistake in either common law or an equity. Lastly, Your Lordship, I would conclude my rebuttal by stating that the respondents have failed to explain the grounds on which the respondents want to seek to avoid the disputed trade. Your Lordship, that's it. It was an honor arguing in the court.
Thank you, Gausia. So in terms of my feedback for both the teams, I think the appellants were quite persuasive, very well researched, and also had relevant case law and legal principles to support their arguments. Both Fazia and Gausia, I would like to congratulate them for presenting their case very effectively and persuasively. They have been very clear and thorough. So I think you have made a good case. Also, from an improvement perspective, maybe you can try and be more innovative in terms of your approach. For example, with regard to jurisdiction or with regard to some of the other points that you made. So try and maybe do some additional research on that front. I know the problem itself is of a highly technical nature, and frankly, the law itself is evolving, but you have made a very good effort. So good, congratulations to you. The respondents made a very good effort in terms of the arguments. Simon, in spite of his limitations with the video, I think he tried his best, and he was he made all the best efforts. In that sense, obviously, Simon, the feedback for you is try and, as far as technical issues are concerned, try and see, that you can do a dry run before the session itself, so as to avoid this in future. Also, your other team member Fatima, she also made a good effort in terms of trying to lay out the facts. So all the best to you as well. But yes, I would have probably expected some more case law reference on your part, and maybe some additional research on legal principles and the arguments. But nevertheless, a good effort, and especially in the circumstances. Wish you all the best to both the teams. So Vishwam, I think we just exit now.
Yes, thank you, everybody. Ocean, you can close the room.
Thank you.